5 seconds. Start. Leave granted. The present appeal challenges the judgment and order of the Division Bench of the High Court of Judicature for Rajasthan Bench at Jaipur dated 24th April 2018, passed in DB Civil Writ Petition number 3260 of 2017, thereby allowing the writ petition filed on behalf of the respondent number 1, Biyani Shikshan Smiti (hereinafter referred to as the respondent number 1) and striking down the notification dated 21st May 2012 (hereinafter referred to as the impugned notification (wide), which the appellant Dental Council of India (hereinafter referred to as the Council) had substituted Regulation 6 (2) (h) of the Dental Council of India establishment of new dental colleges, opening of new or higher course of studies or training, and increase of admission capacity in dental colleges Regulations 2006 (hereinafter referred to as the Regulations) on the ground of the same being inconsistent with the provisions of the Dentists Act 1948 (hereinafter referred to as the said Act) and also being violative of Articles 14 and 19 (1) of the Constitution of India. The facts in the present case are not in dispute. The respondent number 1 had submitted an application to the Government of India for grant of permission for establishment of dental college for academic year 2012-2013 on 24th September 2011. This was after the letter of intent was issued by the state government on 23rd September 2011. The respondent number 2, Union of India, through Secretary, Ministry or Health and Family Welfare (Dental Education Section) (hereinafter referred to as the respondent number 2) noticed certain deficiencies in the proposal of the respondent number 1 and wide its letter dated 7th October 2011 required the respondent number 1 to cure the said deficiencies. After exchange of certain communications on 6th January 2012, the respondent number 2 returned the application of the respondent number 1 along with demand draft of ₹6 lakh on the ground that deficiencies pointed out were not cured prior to 31st December 2011, that is the last date for curing the deficiencies. In the meantime, the Government of Rajasthan issued essentiality certificate to the respondent number 1 on 11 January 2012. However, on 17th February 2012, the respondent number 2 declined the reconsider the application request of the respondent number 1 on the grounds stated in its earlier letter dated 6th January 2012. As such, the request of the respondent number 1 for reconsideration of its proposal came to be rejected by the respondent number 2 vide its communication dated 17th February 2012. In the meantime, vide the impugned notification existing Regulation 6 (2) (h) of the regulation was substituted by amended Regulation 6 (2) (h) on 21st May 2012. Respondent number 1 again submitted its fresh application on 28th September 2012 for academic year 2013-2014. The same was returned by the respondent number 2 void its order dated 31st December 2012 on the ground that the proposal application was not in compliance with the amended regulation 6 within bracket 2 within bracket h of the regulations stop. On 23rd January 2013, the respondent number 1 thereafter wrote a letter to the respondent number 2 stating therein that since essentiality certificates was issued to it on 11th January 2012, the impugned notification was not applicable to it and requested for reconsideration of its application under the unamended regulation 6 within bracket 2 within bracket h of the regulations stop. The respondent number 2 rejected the application of the respondent number 1 void its order dated 5th March 2013 stop. The respondent number 1 challenged the order passed by the respondent number 2 rejecting the request for reconsideration of its application before the learned single judge of the High Court of Judicature for Rajasthan bench at Jaipur by way of SB Civil Writ Petition number 15090 of 2016 stop. The respondent number 1 further sought a direction to reconsider the application submitted by it on 24th September 2011 for establishment of a new dental college for academic session 2017-2018 stop. The learned single judge of the High Court void judgment and order dated 3rd November 2016 finding no merit in the writ petition dismissed the same stop. The respondent number 1 thereafter filed a writ petition before the division bench being DB Civil Writ Petition number 3260 of 2017 challenging the impugned notification amending regulation 6 within bracket 2 within bracket h of the regulations stop. The respondent number 1 also sought a prayer for direction to the respondent number 2 for reconsidering its application dated 28th September 2012 for establishment of a new dental college for academic session 2018-2019 and for subsequent academic sessions stop. By the impugned judgment and order dated 24th April 2018, the division bench of the High Court allowed the said writ petition by striking down the impugned notification and directed the respondent number 2 to reconsider the case of the respondent number 1 in the light of the observations made in the impugned judgment and order stop. Being aggrieved thereby, the present appeal has been directed by the counsel stop. We have heard Sri Gaurav Sharma, learned counsel, appearing on behalf of the counsel stop Stranger.